All right, counsel, I'm ready to hear the motion in the case of State v. Lewis. Prosecution, I believe you've got something for us this morning.
Yes, Your Honor. For our first motion in limine, we anticipate that counsel for defense may seek to introduce evidence that Ms. Tucker has a reputation around campus for promiscuity, as well as rumors stating that she enjoys rough sex. We seek to exclude the evidence of the reputation as it is improper character evidence under 404A. The sole purpose of introduction of this evidence would only be to prove that Ms. Tucker on the night in question acted in conformity with her reputation for promiscuity. As to the rumors, Your Honor, we seek to exclude this evidence on the basis that it is hearsay, as no one will testify that she has a reputation for liking rough sex, just that rumors have been heard. In fact, the defendant himself, if he testifies consistent with his deposition, will state that he heard the rumor from a friend who heard the rumor from other people. Therefore, this is hearsay within hearsay, with no exception, and therefore should be excluded pursuant to Federal Rule of Evidence 805.
All right, counsel, if I understand you correctly, you're raising a 404A and a hearsay argument. Are you raising a rape shield 412 issue at this time, or are you going to respond to that depending upon the defense's position?
Depending on the defense's position, Your Honor.
All right, well, let's hear from the defense what the defense has to say.
Your Honor, we would not be offering Ms. Tucker's reputation, including the fact that she likes to engage in rough sex and is a screamer, as a general attack or as an impermissible 404A argument. Instead, we're offering it, as Your Honor knows, 404A is subject to 412. And under 412, there are some exceptions to the rule where reputation of the victim's sexual history is allowed into evidence. One of those exceptions is when the sexual behavior between the victim and the accused can prove consent, and another is when it is constitutionally required or permissible that this evidence be introduced. Both prongs of the exceptions are satisfied in this case. In this case, the sexual conduct goes far beyond just what happened in the bedroom. It goes all the way back to all of the events at the party. There was a verbal foreplay that was engaged in throughout the course of the night, flirtations, specific references to showing you how to party, and let's take a private party back to my room, that are definitely going to further the notion that there was actual consent in this case. And that's exactly what this case is about. It's about the issue of consent, and there's no tangible evidence. So therefore, that brings us to the second prong of the exception to 412, the prong that it is constitutionally mandated that my client have the right to put on his best defense. His best defense is the fact that there was consent in this case. And therefore, those are the reasons why Miss Tucker's reputation should come in. And also to respond to counsel's second point that there is some kind of division between the fact that she has a reputation for being promiscuous and that she has a reputation for having rough sex and being a screamer. Defense's position is that we see no such distinction. Her entire reputation is that she is promiscuous, and in the course of her promiscuity, she enjoys rough sex and she is a screamer.
I got a question for you, counsel.
Yes, Your Honor.
You want to offer this evidence of character, the reputation, under 404A. So you wish to open the door to the character of the victim as the defense.
Yes.
And you also understand that that's going to open the door to the character of the defendant in the same way.
Yes, Your Honor.
All right. Now, what format do you intend to offer this character evidence if it is permissible under the 412 exception?
Could Your Honor...
What format? Make me a proffer as to how you are going to prove this reputation at trial.
Based upon the defendant's own knowledge, and it's also corroborated by certain of his friends, including but not limited to Mr. Stewart. Mr. Stewart, in fact, had a discussion with Mr. Lewis just immediately, well, not immediately, but a few hours prior to Mr. Lewis and Ms. Tucker engaging in sex, in which he furthered the reputation and said, once again, she has a reputation for being promiscuous, and she likes rough sex, and she's a screamer while she's doing this, and it doesn't matter that she has a boyfriend to her. That goes directly to giving Mr. Lewis the impression that this is the kind of sexual activity that Ms. Tucker likes to engage in. that further explains his actions throughout the night.
Now, counsel, if I understand you correctly, your client will potentially testify as to his understanding of her reputation.
Yes.
Reputation within the community for sexual promiscuity and for engaging in rough sexual activity.
Yes, Your Honor.
And your client would also testify that another individual at the party had reiterated this to him prior to the encounter with the alleged victim.
Yes, Your Honor.
State, how do you respond to this position by the defense?
Your Honor, there is no evidence in this case that tends to prove that Ms. Tucker was promiscuous while engaging in rough sex. We have no idea where the rough sex rumor started. Both witnesses will testify that they are merely rumors and not a reputation. Therefore, we don't know if she enjoys rough sex in a monogamous relationship with her boyfriend or promiscuously with other people around the community. Therefore, the two are not inexorably linked and should not be put on in this case, as this goes much further than the rape shield law. The definition of rough sex, as the defendant understood it and as he heard about the victim in this case, Your Honor, goes more towards the specific instances of conduct, which is not admissible under Federal Evidence 404A.
Response?
Your Honor, as to counsel's first assertion that rumors are to be divorced from reputation, that's simply unfeasible in this case. And in any case, really, what is reputation but founded on what everybody is saying about you, what everybody in your community is saying about you? Here we have a clear case where they're members of the same community, have been for a long time, they've gone to the same college for 2 years, and therefore any idea that reputation and rumors can be dissociated from each other is simply just not how the world works.
Counselor, are you going to be able to lay the foundation for reputation testimony as you have proffered?
Yes.
State, do you have any reason to believe that they'll not be able to lay this foundation testimony?
Your Honor, they will not be able to lay the foundation for the victim liking rough sex or being a screamer, as every witness that takes the stand today, if allowed to testify to that, would only say that they've heard rumors. The foundation required for a reputation is that they are part of a community, that this person has a reputation for this, not that they heard from somebody at some point that this victim liked rough sex.
All right, I am concerned about the ability of the defense to lay a proper foundation. That being said, I think this evidence is potentially admissible as an exception to the 412 shield rule if the defense can lay a proper foundation, both for the reputation testimony and for the connection of the reputation testimony to the defendant. Because I am not certain as to the quality of the foundation that will be able to be laid, at this time I'm going to reserve ruling on this issue, and I'm going to instruct both parties not to mention during opening statements, don't make any reference to the reputation of the alleged victim for sexual activity or to what the defendant may or may not have known about the victim before choosing to go to her room. Do you understand my ruling?
Yes, Your Honor.
Yes, Your Honor.
Any questions?
No, Your Honor.
Any questions from the defense?
No, Your Honor.
All right, let's call the jury.